This is an AZCourtHelp Legal Talk on suing someone, court basics. Thank you.
Our topic today is, we titled it Suing Someone, Court Basics. And my name, as Sarah said, is Kathryn Mahady. I'm at Aspey, Watkins Diesel. I'm one of our civil litigators. And what civil litigation means is just people suing each other. So we'll go over lots of different definitions and which court you can bring which type of case in. It is very basic. So this will get you started and give you kind of an overview if you are in the unfortunate situation of needing to file a lawsuit. So as I said, very basic. The first question is, and the first topic is, what is a lawsuit? And a lawsuit is just asking the court to order someone to do something. And some examples, the most common is pay money. The second is take an action or not take an action. So enjoin someone from doing something. So most lawsuits are about money or some asset that is money in a different form, like a house or a car. But the court tends to, most civil lawsuits are about money, asking someone to pay money. You can also ask the court to order someone to take an action or enjoin someone from taking an action, so not take an action. I put on this slide that a lawsuit is not criminal charges. The only ones who can bring criminal charges are representatives of the government. People talk about pressing charges, dropping charges, but really, we as individuals don't have that power. Only the government or its representative. In Flagstaff, where I'm based, it's the Coconino County Attorney's Office or the city prosecutor or the assistant U.S. attorney for the federal cases. So people cannot bring criminal charges. So we're not talking at all about criminal charges. We're only talking about civil litigation. The way that criminal charges get brought is by reporting someone to law enforcement, and then they decide what to do. Of definitions, and some of these are very easy. Some of them are a little more involved or ones you don't see as much. Plaintiff is the one who's suing. The defendant is the one who's being sued. Now, to make it confusing, if the defendant then countersues the plaintiff, the plaintiff becomes the counter defendant, and the defendant becomes the counter plaintiff or the counter claimant. But usually most lawsuits are one-sided. Someone is suing someone else, and that's the plaintiff suing the defendant. When the court or a court document or one of the parties uses the term parties, that means both plaintiff and defendant. Either plaintiff or defendant is a party. Garnishment is collection on a judgment from wages. Usually it's much more often wages or a bank account. A tort is a personal injury claim. That's all it is. It's a weird name, but and I don't know where it comes from. I'm sure there's a long story for where that term comes from. I don't know. And it doesn't matter for us. A tort is just a personal injury claim. So that's your car crash, battery, that type of injury. Jurisdiction is the court's power to make decisions. So the court has to have jurisdiction to be able to make decisions. The venue is where the case is filed. So Flagstaff, the right venue for these specific claims. And we'll get into how you figure that out. The amount in controversy is how much money is in dispute, how much money is being fought over. And an injunction is an order that the court issues either for someone to take or not take a specific action. And a great resource, as I said at the beginning, our Coconino County Superior Court Law Library is an excellent resource. They have lots of our own forms and then links to state forms. And that's the link there. But if you just Google Coconino County Superior Court Law Library, that's where Google will take you. The second question, so you're going to file a lawsuit. Where do I sue? the first question is, who do I sue? Where do I sue? Small claims court is the place to start if the dispute is only, and I put that in quotation marks because it's very important, but it's only over money. It's not over, you're not asking the court to order someone to do something, or it's not over real property. It's only over money. And the amount in controversy, so the amount of money we're fighting over, needs to be $3,500 or less. And that's not including interest and costs. And the costs would be the filing fee, which is $35. So it's the lowest filing fee of any of the courts we're going to review. And then service of the lawsuit, and we'll get to that too. So it'll be a few $100s, and then interest on whatever debt. You cannot bring multiple claims and add them up to be over $3,500. $3,500 is the most you're getting in that situation in the small claims court lawsuit, not including interest and costs. Attorneys are not allowed in small claims court. So it's meant to be quick and easy, and attorneys, I can say this because I am one, we make things harder and more expensive and more complicated. If an attorney gets involved, the case gets transferred to justice court. And someone who's being sued or suing without an attorney can transfer the case to justice court, or can ask the court to transfer the case out of small claims court into justice court. If they determine that small claims court is not the right place for it, usually just because an attorney gets involved. And there's some information on that link at the bottom for small claims court. The other two courts in Coconino County anyway are justice court and superior court. The filing fees are slightly different in each county. These are the Coconino County filing fees because that's just where I'm based. In justice court, the filing fee is $93. The amount in controversy needs to be less than $10,000. So the fight needs to be over less than $10,000. There are 4 justice courts in Coconino counties: Flagstaff, Fredonia, Page, or Williams. And there's a map to show where your claim falls. It's not usually much of a question. If it happened in Flagstaff, it goes to Flagstaff Justice Court. If it happened near Williams, it goes to Williams. I haven't seen it be all that much of a question which court it should be in for justice court. The superior court, so we're going in order of less to more expensive, less to more complicated cases. So superior court, the filing fee is more than 3 times the justice court. It's $303. The amount in controversy, so the amount we're fighting over, needs to be $10,000 or more. There's 3 different tiers of cases in Coconino County. In any superior court in Arizona, not just in Coconino County. Tier 1 is $50,000 or less. Tier 2 is more than $50,000, but less than $300,000, or non-monetary damages or requests. So that's if you were seeking an order from the court that somebody complete a contract, finish some work on a house, sell you a house. Non-monetary damages or requests, that falls into tier 2. Tier 3 is $300,000 or more or complicated civil cases. So generally, you want the least expensive court that your case fits into. So people start by looking, does my case $3,500 or less? If so, you can go to small claims court. That's meant to move pretty quickly. And then justice court, and then superior court if that's the type of case that you have. Where do you sue? We're still on the same question. For suing a person, the general rule is that you sue in the county where the person resides or where the incident occurred that forms the basis of the lawsuit. So if it was a car crash, you sue in the county where the person who hit you lives, or where the incident occurred, where the crash occurred. And you can check the statute that controls where you sue is ARS 401. And these are all the courts don't keep these secret. The ARS's Arizona Revised Statutes are all available online. There's a link there in the PowerPoint, but you can also just Google ARS 12401. Make sure it's the Arizona State Legislature's version, and then you can get every statute. But that's the one that covers venue and where you file a lawsuit. Now, the second category there, if you're suing a business, you sue in the county where the incident occurs or where the business operates. And you get to pick as the plaintiff, you get to pick where you want to sue, as long as you meet the category or meet the rules that this is either where the person resides for a person or where the incident occurred for either a person or a business, or where the business operates. To start a lawsuit, and I'll show you the form, you file a complaint. That's true in any of the courts, whether it's small claims court, justice court, or superior court. You file a complaint. And like I said, we'll look at the form in the next slide, and I'll show you where to get that. You make factual allegations. So this person did this. This is why I'm suing them. This is what they owe me and haven't paid. This is the damage that they caused my property. You explain to the court, which is who gets the complaint, you explain what did this person do wrong, and what do you want to happen? What do you want the court to order? So you make factual allegations, that's describing what happened, and then you include a calculation of damages. So if it was a car accident and it cost $20,000 to fix your car, or the person had a loan, you gave a loan to this person for $5,000 and they haven't paid you, you calculate the damages. That what do they owe you? Is it to fix the car? Is it to fix the house? Is it money that you loaned that have not been paid back? And then you include a request of the court. What do you want the court to do? And typically that is, I want the court to order this person to pay me. They owe me money and I want the court to order them to pay me. But if it's a different type of request, you include in the complaint, what is it that you want the court to do? Because the court doesn't take these complaints and say, I think this is the solution here. The court's looking at, do you get what you want? So you want to make it clear, real clear to the court, what is it that you want? What is it that you're asking the court to do? This is the form for a complaint. And this came from Arizona Court Help. I think I clicked through to it from the county's Superior Court website. Now, just the forms link, and I'll show you that. What you do at the top, you have the person filing is you. So you give all of your information, and then you put which court you're in. And this one is from the justice court. So you write which court, which justice court you're in. And then the plaintiff is on the left. That's the person suing. The defendant is on the right. You get their name, address, and phone number and email. If you don't have their contact information, that's fine. But the more information you can give, the better. So then the complaint asks you to check a box. Is it tort? So that's personal injury. Is it a contract, or is it a debt? And then asks a variety of other questions, or says that this is basically where you put this information, and then you fill it out and file with the court. This is the rest of the complaint form. So number one is we just looked at, what the claim arises from. And number two is if the claim's recovery on an assigned debt. So it means that there was a debt to somebody and they assigned that right to collect to you. That's kind of unusual. It's surprising that that's the second question, but it is unusual that that's the situation. If it doesn't apply, you just write NA. Number three is just a statement. This court has jurisdiction over this matter. And then for number four, you're telling the court why the venue is correct, whether it's that the defendant resides in this precinct or the incident occurred in this area. Number 5 is the defendant owes you money or owes the plaintiff money or property because, and these are the factual allegations. Number 6, the amount I am requesting can be calculated with certainty, which is always great. If it's a debt with a clear amount of or clear interest percentage, you calculate the outstanding amount of the debt and the interest, and you write that number there. The question in the chat was, what if the damages cannot be calculated at the moment, and like medical debts that are still accruing? So what you do in that situation is you check that box. You're asking the court to award judgment in the approximate amount of, you just describe, you give the number you have for now and describe the damages underneath. The court will have to have a hearing to establish your damages. Number 7 is you're also asking for reimbursement of the following. Attorney's fees are available in a contract, but not in every case. So in every contract, you can ask for attorney's fees, and you would think it's reasonable to get attorney's fees on if you win on any case, but unfortunately that's not accurate. You can ask for pre and post judgment interest and court costs. It depends on the case what your damages are, but then you swear under penalty of perjury that the foregoing is correct and sign, and you give that to the court. This is the document that the court issues. So you still write in all your information and the court information and the plaintiff's name, defendant's name and address. And all you're really doing is helping the court issue this summons by giving this information. So the summons is notice to the defendant that they're being sued. And the defendant needs to file an answer, and we'll get to that in a second, to avoid being defaulted. So if you don't file an answer, the other side wins. If you're being sued and you don't file an answer, then the other side will get a default judgment. If you're suing someone and they don't file an answer, you can file for default. So this one, you'll see on the second page here, the judge signs or the clerk signs these summons, and that's what you serve with the complaint on the defendant. You need to attach a civil cover sheet to any lawsuit that you're filing. And the clerk's office has this. There are a large variety of different types of cases that it could be. And so just look and you figure out the one that's closest to yours. Most are way more complicated, like a water right and variety of other things that show up here. Most of ours are just basically contracts and torts. So this all makes sense. You find the one that's closest to your case and check that box. And so the clerk will have that, or you can find the forms online. All the forms are here. The complaint, the summons, garnishment forms later if you need those after a judgment. But you can also just Google Arizona Court Help, and if you don't have this link, you can get to all the forms that the Arizona courts offer. Within 90 days of filing the complaint, the plaintiff, so assuming the plaintiff is you need to have those documents, the complaint and the summons, served on the defendant. And that needs to be within 90 days. And then you need to show the court that you did that. The reason for that is that the person that you're suing needs to get notice that they're being sued, that you're suing them, and to get the timeline for an answer, which is 20 days. Most service for lawsuits is done by a process server. It costs about $200. Each process server charges differently, but it doesn't need to be a process server. It can't be you, but it can be done by any person over 18 years of age who's unrelated to the case. We use the process server because they know how to draft the affidavit that a process server in fact, ours files it for us. so that we can show the court that we did serve the defendant in case they don't answer. But it doesn't need to be a process server. It can just be anyone over the age of 18 who is unrelated to the case. So it can't be you. And sometimes there's some safety concerns. So it's another reason to have a process server do it.
A sheriff or sheriff's deputy, a constable or constable's deputy, or a private process server can perform personal service.
Service of process on a person, so service of the complaint and summons. If you're serving a business, the complaint and summons is still what gets served. You can serve the statutory agent, which you can find at the Arizona Corporation Commission website. If it's a corporation, you can serve the Arizona Corporation Commission. They take forever to get the complaint to the company, or you can, if it's an LLC, you can mail the complaint and the summons. But the safest rule, the quickest way to get a reaction is to serve the statutory agent, to look that up in the Arizona Corporation Commission website. If you can't find the defendant, or the defendant is really actively avoiding service, which happens pretty often, then the court can give you permission to serve by publication, meaning that you publish the complaint and the summons in a newspaper for a certain amount of time. And I don't remember offhand how long it is, but then you show the court that you did the publication, and the court says basically that is enough. You did what you're supposed to do. You have to try to find the defendant first, because defendants never see the publication with their name on it. We've had one that I know of ever at AWD where the person was a defendant and they saw the publication of the summons and then responded to that. So it's extremely unusual that the defendant actually sees it to file an answer, but you have to try to find them before the court will give you permission. That's if you can't find them. Defendant's responsive pleading is an answer, usually. It can also be a motion to dismiss or a couple other types of motions, but usually it's an answer. So if the defendant is served in Arizona, they have 20 days to file an answer or move to dismiss. And the answer admits or denies the complaint's allegations. So when we write a complaint, we write different paragraphs, and the answer goes through and says, I admit paragraph 1, I deny paragraph 2. And each paragraph is a separate factual allegation. But basically the answer says, no, I admit some of these things, I deny others, or admit all or deny all of the allegations. So that's what comes in the answer, which needs to be 20 days, filed 20 days from the date of service in Arizona. If the person served outside of Arizona, they have 30 days. And there's, you can ask to waive service and then you get 60 days, but that's a little beyond where we're going to go today. A counterclaim, and I talked just very briefly about a counterclaim when we were talking about the plaintiff and defendant. With their answer, the defendant or the defendants may file one or more counterclaims, and that's their suing now, the plaintiff. So it happens pretty often. The plaintiff sues and the defendant says, no, this wasn't my fault. It's actually your fault. And they counterclaim against the plaintiff. So that means that each party's suing each other. The plaintiff needs to file an answer then to the counterclaim within 20 days of the counterclaim filing. So that's if the parties are suing each other, both sides suing each other. A lot of lawsuits go to default. And what default means is that the defendant or the defendants, they didn't file a response. They didn't file an answer. They didn't move to dismiss within, I said 20 days of service. That's true for Arizona, unless it's longer because they were outside of Arizona or got an extension. If the defendant does not file an answer within the amount of time that they are allowed, the plaintiff can file for default. The default is effective 10 business days after the plaintiff applies for default, unless the defendant comes in and files an answer or a motion to dismiss. So what happens as a practical matter is we sue, have the person served, file proof of the service with the court, and then from the date of the service is 10 days. In court days, 10 is business days. 11 is calendar days. I don't know why, but it is. So 11 days is actually fewer than 10 for court purposes, because 10 days for court is 10 business days. So we filed an application for entry of default last week. I think it was on Thursday. That means that next Thursday, that default will be effective. And that means that we have default against the defendant. And so if they come in after that time, they have to move to set aside default, and they need to prove that there was a good reason that they didn't file an answer, usually that they didn't actually get notice. This is an application for default, and it's pretty self-explanatory. Again, in the upper left, you put your information and then the court, and then in the middle of the paper, the plaintiff and the defendant. And you're basically telling the court, this person got served at this time, date, etc. And so they had 10 days from the date of that service. They haven't filed. So we're asking the court to enter default. Default is great, but it's not the judgment. There's one more step, one more box you have to check. After 10 days, if the defendant does not file an answer, of 10 days after the application for entry of default, the plaintiff needs to file a proposed default judgment or request a default hearing. So that's for the judge to say how much this defendant owes you or what the defendant needs to do, and issues an order for whatever it is that you're asking for. I've had people show up at this point where we sued, the person didn't file an answer, and they showed up at the default judgment hearing, and the court says, I'm sorry, that's too late. You had an opportunity to file an answer and you didn't. That's if the defendant doesn't answer. If the defendant does answer, then after the answer and or the counterclaim, the parties start to collect evidence from each other, and you have to disclose everything that's related to the case. I know it doesn't seem that way when we watch law shows or law movies. It doesn't seem like we have already told each other all of this, but that's the way it actually is in law practice. There are no secrets. We tell each other everything about our case and disclose all the evidence, all the documents, all the witnesses, so that we know what the other side is arguing. And so that's called disclosure. Depositions are when one of the parties asks the other party questions under oath. We can also serve discovery requests, and they take three main forms: non-uniform interrogatories, fancy name for questions to the other side; requests for production, that's when we ask the person to produce these specific documents. So we just served one for bank statements; or requests for admissions. And you can do all three of these. The request for admissions is we send a statement saying, I was involved in this car crash, admit or deny. And the person has to admit or deny. And those are the discovery requests. That's during the discovery section of the case. So that's after an answer and or a counterclaim. Every county sets an amount in controversy for mandatory arbitration. What mandatory arbitration is that you have to go to somebody who the court appoints. It's usually a lawyer who serves as basically the judge. If the amount in controversy, so the amount of money we're fighting about, is less than the mandatory arbitration amount in that county, the case has to go to arbitration. In Coconino, it's $65,000. I believe it's $65,000 in Yavapai too. There's some other counties, real small counties, where it's $1,000. So very few cases go to mandatory arbitration. The court appoints an arbitrator who is basically the judge. Arbitrator holds a hearing and issues a decision just like a judge. It's meant to move the case faster. And as far as I can tell, there's either no way around the mandatory arbitration or no way I have found. So if your case is subject to mandatory arbitration, you need to go through arbitration with an appointed arbitrator. The trial is what we usually see for movies, law shows, because that's exciting. The bulk of the work, though, is the lead up to trial, which does not make for good TV or movies. In a trial, and it depends whether it's a jury trial or a judge trial, a bench trial, the plaintiff needs to prove all the elements of their case. That's the plaintiff's burden, to prove their case, to get the judge or the jury, whoever's hearing the case, to say that, yes, they have met these elements, they have established that they meet the rule here. Plaintiff goes first. They present witnesses and documents. The other side can cross-examine witnesses. And then the plaintiff rests. So the plaintiff gets to give their whole case first. The only thing that the defendant gets to do is cross-examine witnesses. So ask questions of the witnesses. And then the plaintiff rests. And then the defendant goes. The defendant presents their case, including any counterclaims. They present their witnesses, their documents, everything that supports their case. The judge or the jury, and actually the trial's the same process for arbitration. You have to prove your case as a plaintiff. You defend yourself as the defendant. And the plaintiff goes first, defendant goes second. The judge or the jury will issue a decision following the trial. Now, the successful party, so if you win, you submit to the court a proposed judgment. The interest from the date of the judgment is the federal prime rate plus 1%. And I need to update that. I think it has gone up. So the currently interest post-judgment interest, at least when I wrote this, and I do think it has changed just slightly, was 8.75%. Pre-judgment interest is always 10% unless there's a different interest rate in writing. So if it was a car loan at 8%, pre-judgment interest is 8%. If it was just somebody loaned money to someone else and they didn't talk about the percentage interest, it's 10% for pre-judgment interest. So that's before the court issues the judgment. It's collecting on a judgment. The court has no involvement. It will not help you collect on a judgment. So the judgment is you win. The judge issues an order saying the defendant needs to pay you this amount of money. Or sometimes the plaintiff needs to pay the defendant a certain amount of money. The court does not take any role in collecting on the judgment. That is all your responsibility as the party. It is possible to garnish wages and bank accounts, and the garnishment forms I linked to there. Garnishment of bank accounts is trickier because you only get the money that's in the bank account that day. And there's now I believe it's $5,000 exemption. So anything up to $5,000, you don't get. You only get what's over $5,000. Wages are a little easier, and you get paid every time the person gets a paycheck. So it's a long process. There's about 14 forms that you have to do, but the self-service instructions are actually really good. If you get a judgment and you know the defendant or the other party owns real property in a certain county, you can record a certified copy of the judgment to create a lien on non-exempt real property. And now, since at the beginning of this year, Proposition, I think it's 209, those liens stay in place even if the person files for bankruptcy, unless they have the court set aside that lien in the bankruptcy.
Thank you very much for joining us.